Welcome to the Deep Dive. This is where we take sources you send us and, well, we pull out the key insights so you don't have to wade through everything.
Think of it as your way to get up to speed, fast.
Exactly. And today, we're digging into something pretty interesting, a slice of a court hearing.
That's right. We've got an excerpt from the Supreme Court of the state of New York, Queens County. It happened March 26th, 2025.
And the case name. It's Julianne E. Holton versus the New York City Transit Authority, Kai Arraez, a Dewey Pile, Inc., and Erie DeRonan. Quite a few parties involved.
Yeah, a full list. A listener sent this in basically wanting to get the main points of discussion, maybe spot any conflicts or interesting bits without getting bogged down in all the legal speak.
Right. So our mission here is to unpack what's important, maybe highlight anything that jumps out as, well, surprising.
So, just to set the stage, the plaintiff is Julianne E. Holton, represented by Cohen and Cohen.
Okay.
And on the defense side, you've got the NYC Transit Authority and Kai Arraez, represented by Kritzer Law Group. And then there's a Dewey Pile and Erie DeRonan, represented by Sobel Pevsner, LLC.
Okay, lots of lawyers. And this specific bit we're looking at, it's not the whole trial testimony, right?
No, not at all. It's a discussion before things really get going, it seems. It's between the plaintiff's lawyer, Mr. Kim, the lawyer for DeRonan, and a Dewey Pile, that's Mr. Sobel.
Okay.
And the judge, Honorable Joseph J. Esposito. And they're talking about a witness, a Dr. Gerling.
Dr. Gerling. Okay, let's get into it. What's the first thing they hash out?
Well, it kicks off with Mr. Kim, the plaintiff's lawyer, trying to get some clarity from the judge.
Clarity on what, exactly?
On how far the questioning of this Dr. Gerling can go. You know, what topics are fair game. He wants to know the boundaries before the witness even testifies.
Trying to set the rules of engagement up front. And how does the judge respond? Does he lay it all out?
Not really, no. The judge basically says, look, I can't give you a ruling in a vacuum. I don't know what Mr. Sobel is going to ask yet.
So wait and see.
Pretty much. He tells Mr. Kim, if you think a question goes too far, just object then, and I'll rule on it.
Okay. And Mr. Sobel, the defense lawyer, does he chime in?
He does. He mentions, interestingly, that he hasn't actually written out his specific questions yet, which he says is his usual way of doing things.
It's all a bit up in the air at this point. No one knows exactly what questions are coming.
Right. And then Mr. Kim brings up another point, a slightly different angle.
What's that?
He asks about whether references can be made to the lawsuit itself. Like, can they talk about whether the case was settled or how much it might have settled for?
That seems like a sensitive area. Does he have a reason for bringing that up?
Yeah, he cites a case, People versus Smith. He says it stands for the idea that you generally can't mention lawsuits or settlements, especially if there wasn't any admission of wrongdoing.
Because it might prejudice the jury. Make them think something happened or didn't happen based on a settlement?
Exactly. He's trying to preemptively block that line of discussion based on this precedent. He seems to be referring to a previous ruling in New York that settlements without admitted fault shouldn't be mentioned.
And does the judge ask about the settlement directly?
He does. The judge asks Mr. Kim point blank, did this case settle or is it still pending?
And what does Kim say?
Mr. Kim says he believes there was a settlement, so that immediately puts the issue on the table.
Okay. And Kim also mentioned something else, a Lopes matter.
Yeah, the Lopes matter. It sounds like another case he's referencing. Apparently, in that case, a judge didn't allow questions put to a doctor asking if they were aware of certain allegations.
So Kim's worried about a kind of backdoor approach.
Seems like it. He wants to make sure the defense doesn't try to get information about the lawsuit in by asking Dr. Gerling if he knows about the allegations, rather than asking him directly about his actions.
Trying to prevent an end run around the settlement issue.
Right. He's flagging it for the judge and for Mr. Sobel, but the judge kind of cuts him off there, tells him to let Mr. Sobel finish his point.
Okay. So how does Mr. Sobel, the defense attorney, take all this advice from Mr. Kim?
Well, not very well. He objects pretty strongly.
To being told what he can and can't ask.
Yeah. He basically says, look, the court will rule on my questions when I ask them. I don't need Mr. Kim telling me how to do my job or previewing my cross-examination.
Okay, a bit of friction there. How does the judge handle that?
The judge smooths it over a bit, says, okay, Mr. Kim was just seeking clarification, and I think he got it.
And does the judge give any indication about how he'll rule on these things? Like, will he follow that People versus Smith case Kim mentioned?
That's a key point. The judge specifically says he is not bound by that Suffolk County case, People versus Smith.
Oh, even if he followed it before?
Right. He acknowledges he might have followed it in the past, but says he can't guarantee the same rulings here. It all depends on how the questions are actually phrased.
So no promises. But does he say anything about questioning Dr. Gerling's background?
Yes, he does. He confirms that Mr. Sobel will be allowed to ask questions about Dr. Gerling's background.
To try and impeach his credibility.
Exactly. That line of questioning seems to be definitely on the table.
Okay, so Kim tried to set boundaries, Sobel pushed back, and the judge is keeping his options open but signaling that Gerling's background is fair game. This is where things get really interesting, right? With the judge's own view.
Absolutely, because Mr. Kim then raises a concern, the classic you can't unring a bell argument.
Meaning, even if the judge tells the jury to disregard something improper, the damage might already be done.
Precisely. He's worried that even with instructions, if prejudicial stuff about Dr. Gerling comes out, it will taint the jury's view.
And the judge's response to that concern is, well, it's something.
It really is. The judge, speaking just among us, as he puts it.
Which is already a bit unusual for the record.
Right. He calls Dr. Gerling's background disgraceful.
Okay, that's strong.
Very strong. He says he intends to give Mr. Sobel a lot of leeway in questioning him so the jury can understand the truth.
The truth about Dr. Gerling specifically.
It seems so. The judge says he's sick and tired of certain medical people and feels insulted by whatever Dr. Gerling is involved in here. He even says it borders on criminality.
Borders on criminality. That's incredibly pointed language from a judge about a potential witness.
It is, and he doesn't stop there. He explicitly says, I am going to unravel him at this trial, and that he'll be very hard on him.
Okay, so the judge has clearly formed a very, very negative opinion of Dr. Gerling before he's even heard him testify under oath.
It certainly appears that way, and Mr. Kim picks up on this immediately.
Understandably. What does he say?
He expresses concern that the trial is suddenly shifting focus, that it's becoming less about his client, Julian Holton, and more about putting Dr. Gerling on trial.
And the judge's response?
The judge basically confirms it. He says yes, the focus is on Dr. Gerling's credibility, and that the defense counsel, Mr. Sobel, will reveal his bad acts.
This really brings up that legal balance, doesn't it? Probative value versus prejudice.
Exactly that. Mr. Kim makes that argument directly. He says, whatever is in Dr. Gerling's past, it has nothing to do with this case, meaning his client's injuries and who was at fault in introducing it, is purely prejudicial to Ms. Holton.
He's saying essentially, don't punish my client because you don't like this doctor we hired.
Right. He's arguing the potential harm to his client's case far outweighs any relevance Dr. Gerling's background might have to the actual accident or injuries. It might make the jury dislike Gerling and maybe dislike Holton by association unfairly.
And the judge's reply to that argument is perhaps the most remarkable part.
It's quite something. The judge suggests the plaintiff should have gone to a different doctor.
Whoa.
And then he says, putting it on the record, they are all in cahoots.
They are all in cahoots, meaning the doctors, or doctors and lawyers. It implies collusion.
It strongly implies collusion, or at least a deep suspicion from the judge about the whole system involving medical testimony in these kinds of cases.
That feels like a huge statement to make on the record in open court.
It absolutely is, and it leads directly to the judge's next point.
Which is?
He strongly suggests they settle the case.
After basically saying he intends to let the defense tear apart the plaintiff's key medical witness and believes doctors are in cahoots.
Yes. The implication is pretty clear. This witness is going to be heavily attacked, and the judge seems inclined to allow it, so maybe settling is the best option for the plaintiff.
And how does Mr. Kim react to that suggestion?
The transcript just says Mr. Kim indicates he will make a phone call.
Which sounds very much like he's going to call his client or senior partners to discuss settling, given the judge's stance.
That seems the most likely interpretation, yes. And right after that, the proceedings move on to jury selection.
So this whole intense discussion happened right before they started picking the jury. A critical moment.
Definitely sets a certain tone.
Okay, so let's recap the key tensions. We had the initial skirmish over how much leeway the defense would get with Dr. Gerling.
With Kim wanting rules and the judge saying, wait and see.
Then Kim's concerned about mentioning the lawsuit or any settlement, citing precedent.
Which the judge said he wasn't necessarily bound by.
And then the big one. The judge's really forceful, negative opinion about Dr. Gerling expressed openly.
Yeah, calling his background disgraceful, bordering on criminality, and saying he'd unravel him.
That's got to be the aha moment here, right? The sheer candor and strength of the judge's personal view on a witness before testimony.
Absolutely. It's unexpected and raises immediate questions about impartiality, or at least the appearance of impartiality. It moves way beyond just ruling on evidence.
It really does. When you listen to this, what stands out most to you? For me, it's just how raw and human it feels, how these strong opinions can surface in such a formal setting.
I think for me, it's that tension between uncovering truth. The judge seems to believe Gerling is hiding something or is disreputable and ensuring fairness. Kim's point about prejudice is valid. Is it fair to potentially damage the plaintiff's case because of issues with a witness that might not be directly relevant to her specific claim?
That's the crux of it. The judge wants the jury to know the truth about Gerling, but is that truth relevant to this trial or just prejudicial?
It's a fine line, and the judge seems determined to let the defense explore it heavily.
So here's a final thought for you listening in. Given how strongly the judge feels in what he signaled he'll allow, how do you think that might realistically affect a jury?